Yeah, thank you, Christian. Let me get my sharing. Okay. Mm, Okay. Can everyone see that? Yes. Okay. So just an introduction. My name is Raleigh Maxwell. I debated all 4 years of high school at Montgomery Bell Academy, and I will be debating at Emory University next year while also coaching MBA. Today I'll be giving the topic lecture on intellectual property. Um, If anyone has any questions in the middle of it, please feel free to unmute, ask me questions. We'll also do Q&A at the end if you want to write your question down. Just as a brief disclaimer, this topic is pretty complicated. There's a lot of information and concepts that may fly over your head. I know that happened for me when I started researching it. That is perfectly okay. Hopefully today in this camp will be a good introduction to the topic and help you kind of navigate those difficulties. I'll move a little fast just because there's a lot of content I want to cover. So please feel free to unmute, ask me to slow down, ask me to re-explain something. I'm definitely willing to do that. All right, let's get started. So the presentation is broken up into 6 parts. The first part is a discussion of the resolution. So that's kind of what we're debating this year, what the affirmative is required to affirm, what the division of ground is for the negative. The second thing we'll be talking about are basics on what intellectual property is. So that's kind of like, why was IP created? Who created IP? What are the types of IP? Just really important concepts to kind of grasp the basis of the topic. The third section will be core controversy. So these are 6 areas of the topic we'll go over that I think are really important and will become the kind of like core controversy over protecting intellectual property. The fourth section will be AF angles on the topic, so like different affirmatives you can write under each topic area. And the final section will be how to negate the topic. All right. So the first part is the resolution. So the resolution this year is the United States federal government should significantly strengthen its protection of domestic intellectual property rights in copyrights, patents, and or trademarks. So this year we are debating intellectual property. Obviously, it has actually never been a debate topic before in any form of debate, so it's a unique topic. There's not been a lot done in the debate world on intellectual property. So the first part of the resolution is United States federal government. That denotes that the federal government, as opposed to the states, must do the action. And then we have strengthen its protection, which could mean a number of things, including making it easier to obtain intellectual property rights, thereby like expanding the scope of protection of intellectual property rights. It could also mean increasing enforcement, right? So like if someone infringes your intellectual property rights, then you can be provided a remedy to that infringement, which we'll talk more in depth about later. And then the 3 sections of the topic that you kind of have to operate under are copyrights, patents, and trademarks. So we'll go over what each of those mean and kind of different affirmatives you can write in each of those areas. So the second thing I want to talk about are just IP basics. So kind of what is intellectual property and why does it exist? But I think before we talk about intellectual property, it's important to understand basic components of just property. So property is what we call a negative right. So negative rights means that you have freedom from interference. So another negative right would be like a right to free speech, right? Your free speech cannot be infringed by the government or by any other party. That's a negative right. That's distinct from a positive right, which is kind of like an entitlement to act is the best way to explain it. So a positive right would be like a right to vote, right? So property in US law is a negative right, meaning that no one can infringe upon your property, no one can interfere with it. So our understanding of property is kind of rooted in John Locke's ideology of how like property arises. It kind of has like it's a natural phenomenon, right? So it's like created by nature. We all have equal rights to the property of nature, but when one person decides to improve like one part of nature, they then make it their own property. So like land is a very common form of property. If you kind of like improve your own plot of land that becomes your property under like the John Locke's ideology. So that kind of has formed the basis for a lot of US law concerning property. And I think it's just important for understanding like the justifications behind intellectual property. So speaking of justifications, why do we protect property rights? The main reason is just that the holders of those property rights are incentivized to preserve their property, to improve their property. And we'll talk about specifically like how that applies to intellectual property and why we protect intellectual property. So then the kind of what intellectual property is it's property created by the mind, right? So it is intangible, it's ephemeral, it's some sort of like idea or thought. That is what intellectual property is. And it's typically for a set duration of time, which kind of distinguishes it from other forms of property. So most IP is only you're only allowed to hold it for a certain duration of time. It varies between the different types, but that's kind of what distinguishes it from other forms of property. So the constitutional basis for intellectual property protection, it comes from the Article 1, Section 8 of the Constitution, which reads as follows. The Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. Right. So like in this clause, you can kind of see why Congress thought it, or the Continental Congress thought it would be useful for us to have intellectual property protection, right? So that's like to promote the progress of science and useful arts. So it's kind of a way of incentivizing in like invention, incentivizing innovation, right? The other important part of this, I think, is the part that says limited times, right? So they only have those exclusive rights for limited times as stated in the Constitution. That kind of section has been subject to some debate over what it means, and it's definitely been reformed over the years, like what limited times mean. So the next thing I want to talk about is the history of copyright because I think it is pretty interesting, first of all, but second of all, I think it provides a useful way of like looking at the topic. So US copyright law and intellectual property law kind of evolved from English intellectual property law, and that began in 1557 when Queen Elizabeth granted the Worshipful Company of Stationers exclusive rights over publishing. So that was a group of people who publish books, publish other forms of like literature, and the Queen of England kind of granted them exclusive rights over that. And then when that expired in 1710, the first kind of legal regime for copyright in like the Western world was developed via the Statute of Anne. That granted monopoly for only 14 to 21 years, right? So that's a shorter duration of time than US law currently has it. Only 14 to 21 years, not very long at all. So then obviously the founding fathers used kind of those laws as the basis for the constitutional clause on intellectual property protection, which we just looked over. And then the Act of 1790 was the first copyright act to actually set a duration. And it set the duration as 28 years. So already we're kind of seeing an increase in the duration from 14 to 28. And then by 1998, after a series of copyright acts, it is now can extend to up to 95 years, which is really just a huge departure from what it was kind of originally. And funnily enough, the main reason for that has been Disney. So each time Steamboat Willie or Mickey Mouse has come close to losing its copyright, Disney has lobbied for copyright broadly to be extended, which I think just is kind of a testament to how important intellectual property can be for certain companies. So we'll talk about kind of the rights you get when you have copyright over something, but Disney did not want to lose their rights to Mickey Mouse, and so they continue to lobby for longer copyright protection across the board, not just for Mickey Mouse. Disney is not alone in lobbying for stuff, which we'll talk about later, but I just really think this is interesting how like one company can affect copyright so broadly and change it so much from what it was originally intended for. Okay, so types of IP, I think, will be the bulk of the lecture today, because it's important to kind of know what distinguishes them and how each of them work. So the first type of IP we'll go over is patents. Patents are the will probably be the biggest part of the topic this year just because they get to the biggest impacts and there's a lot of literature on them. So patents, by definition, are a state-granted limited monopoly over a technical invention, a product, or a process. So that's like medical technology, pharma, biotech, like engineering, like appliances, like mechanical devices. So those are the kind of things that get patents. They're kind of like the machines, the drugs. Those are the things that get patented. The duration of patents are around 20 years. So after 20 years of your patent, that patent is then like published to like the public domain, and anyone can reproduce something based on that patent. But the duration depends on the type of patent. So there are three types of patents, the three most common types. The first type is a utility patent. It is the most common of the three. The pharma patents are the most popular, are very popular on the topic within utility. So utility patents are like the ones you would think of: machines, processes, systems, drugs. They last for 20 years after the patent is granted. Um, the second type of patents are design patents. Those refer to patents on exterior look. So the Coca-Cola bottle has a design patent. Those last for 15 years, not 20 years. Yeah. And then the final type is plant patents. So those kind of are patents on what they call like distinctive new variety of plants. So when you modify a plant, you can patent that, and then you get to hold that for 20 years. So the rights granted to patent owners, they have the right to exclude others from doing things like making, using, selling, or like importing like into the US the invention claimed in their patent. And we'll talk about ways that you can kind of go about like um if people are infringing on your patent, how you can remedy that. We'll talk about that in a second. So the way that you obtain a patent is you apply to the Patent Trial and Appeal Board, which is an agency in the U.S. Patent and Trademark Office. You apply to them to obtain your patent, so you have to file with them, and then they then have professionals who determine if your patent is granted based on a certain requirements. So the requirements are pretty important for understanding. Or first, before we go to requirements, there are two different types of patent systems and like how we apply for patents. The first one is called a first to file system. So a patent is awarded to the first person to register their patent. Even if someone has already kind of invented the idea before you, if you have not filed first, then you are not granted the patent. The second type of system is first to invent. So if you are the one who creates the invention first, then you are the one who is awarded the patent. The US had first to invent until 2013, and then Congress switched the system to first to file. So I think it's useful and interesting to talk about the pros and cons of a first to file system, just because I think it kind of speaks to the utility of patents and like the way that our system works. So the major benefits of a first to file system is that it's easier to adjudicate, right? So it's pretty difficult to decide who kind of invented something first. Like, what does it mean to invent something? What does it mean to create an idea? Does it mean you have to write it down? Does it mean it has to be in commercial use? While like first to file is pretty easy because it's just like, when did their application get to the Patent and Trademark Office first? It also encourages more filing. So if people are incentivized to file as quickly as possible so they can get their patent, then they won't kind of just hide their invention and rely on trade secrets, which we'll talk about later. They're kind of complicated, but we'll break it down in a little bit. And the last reason is international harmonization. So a lot of other nations have first to file systems, which is one reason why the US adopted it. In 2013, like international harmonization was a large justification for it because there are a lot of international elements of intellectual property. The reasons why first to file might not be the most effective system is some people think that it's worse for small inventors who are kind of face like a lot of costs when they file a patent, because a lot of like time and work has to go into like writing a patent application, making sure that it meets all the standards. So it's very hard for small inventors to actually file patents. It also removes the grace period after inventing. So there's kind of like an incentive now to file as quickly as possible, which means that some people might not be able to refine their invention before they have to kind of file it and get a patent on it. And the final reason is that it might let the patent office ignore prior art. So if someone has already kind of used your invention or it's already in use somewhere, then if they have not filed for a patent, then the patent office can ignore it. We'll talk more about prior art and what that kind of means in a second. So that the impact of that is kind of like it ruins the fairness of the system, right? So someone who's actually created the invention is not actually awarded the patent. And the final aspect of patents are the requirements to become a patent. So these are the things that the PTAB looks at when they're deciding whether or not to award the patent. So the first three standards are um, novelty, which basically just states that it must be new. If it is in public use before, or is in public discourse or public sale, then it is ineligible. So like I cannot patent something that is in use or known already. Um, yeah. And then the second requirement is that it must be useful. It must have a credible utility. It must be, I think the phrase they use is specific, substantial, and credible utility. The third standard is non-obvious, which means that you cannot patent something that would be obvious. The best example of this, I think, is like stealing two other patents and putting them together. That does not make a kind of unique product. That just means that it was kind of obvious that you could have done that, so you can't patent those two things. And the final requirement is enablement. So a large reason why the US has an intellectual property system is one, to kind of award investor or inventors for their designs. They get like protection for 20 years, but after those 20 years, their patent and the very specific details of how their invention is created, those are then like published right to the public domain, so anyone has access to them. And so the final requirement of a patent is kind of like a detailed description of what the invention is, right? So that's the specification part. So the patent application has to have those elements. It also has to have the disclosure part, which defines like what the property right is. So that's kind of like more like legal requirements and less like requirements on what exactly the invention is. And then the final requirement is that it cannot be in non-patentable subject matter. So these are a few categories for kind of what you cannot patent. So the first one is like if it is abstract or impossible idea, right? So like I cannot apply to the patent office and say, I would like to patent time travel, right? Because that is not really, or at least currently, that is abstract, right? There's no real credible design or way of actually time traveling. The second non-patentable subject matter is law of nature. I cannot patent gravity, for example. Then scientific principles, can patent like the second law of thermodynamics and then require other people to pay me to use it. You can't patent math algorithms. I can't patent addition. You can't patent mental processes because that just be impossible to enforce. And then non-functional descriptive material is a little confusing. Basically, it means that like if you add something to prior art, which just means like an invention that existed before, if it does not change the function of the prior art, is not patentable. So I think the best example is like a playing deck of cards, a deck of playing cards. If you add images to the cards, that does not make them like distinct from a patent on playing cards, right? So like if I have a patent on playing cards and someone else puts like an image of Mickey Mouse on them and then applies for a patent on like Mickey Mouse playing cards, that will be non-functional descriptive material because those cards are only changing like the appearance of the playing cards and not like the design, right? They're just decorative. The other thing you can't patent, the other things you can't patent are naturally occurring organisms. So I cannot patent like the heart, obviously. And then the final one is economic methods. You cannot patent like a business process, like a way of conducting sales, for example. Yeah, so those are kind of the 8 categories of things you just can't patent. And those are pretty useful to know just because a lot of apps will kind of tweak what the definition of each of these are or just totally remove some of them. So the next type of IP that we should talk about is copyright. So copyright protects expression, which is really important distinction because expression is not ideas, right? So my favorite example of this is the movie Spaceballs. So I'm sure all of y'all are familiar with Star Wars, right? So Spaceballs is a spoof movie of Star Wars. So it kind of has the exact same idea of Star Wars, right? There's a villain who looks a lot like Darth Vader. His name is Dark Helmet in Spaceballs. There's a Chewbacca-like character. His name is Barf. There's a Pizza the Hut in Spaceballs. There's a Yoga-like character. His name is Yoga. There's a Princess or Leia-like character. Her name is Princess Vespa. Han Solo is Lone Star in Spaceballs. There's also a female version of C-3PO. So the reason that Spaceballs is kind of legal is that it is has the same idea of Star Wars, right? Like it's a very similar storyline, but it is a different way of expressing that idea. So Spaceballs takes like a different way of expressing the idea of some like galaxy far, far away where there exists some like force, which in Spaceballs they call the Schwartz. And so that is why like that is still legal. Like even George Lucas signed off on the movie with the requirement they can't like use it for merchandise. Yeah, so that's kind of like a good way of explaining why copyright refers and protects expression of ideas rather than just the idea itself. Okay, so the duration of copyright can either be 70 or 95 years. It depends on like who is the one that copyrights it, right? So if it is the author who's copyrighting their own work, then the duration of the copyright extends to 70 years after their death. Um, and if it is work made for hire or an anonymous work, the copyright extends 95 years after the first publication. So work made for hire is typically like if I'm an employee working for a company and I create something that is copyrightable, that means that that's like a made for hire copyright. And the owner of the copyright is actually like my employer, which is important to know just because I'm sure that will come up this year in debates. So work made for hire means that it only extends for or it extends for 95 years after you create that work. An anonymous work is just like any form of work they don't know who the author is. It's protected under copyright for 95 years after the first publication. Yeah, so the rights granted to people who own copyrights, they have the exclusive right to copyright. They have the exclusive right to share, perform publicly, or generate sequels to a work they have created. So they kind of control all the display and licensing. So like if someone were to use Star Wars, for example, on like a lunchbox and it wasn't signed off by like Lucasfilm, that would be kind of stealing their copyright. So they have the right to kind of take that to court and get remedies for your infringement. The way you obtain copyright, so it's actually formed upon creation. So it's kind of like a first to invent system a little bit. So like when you have created your idea, then you already kind of have that copyright. But in order to defend it in court, you must register with the Copyright Office, which is part of the Library of Congress. And so the requirements for kind of what it means to like be formed upon creation, the phrase they use is a tangible medium of expression. So for like, let's say like a literary work, for that to be a tangible medium of expression, it must be fixed in a book. Like a musical work must be fixed on like sheet music or like in a digital file. But if it is not in a tangible medium of expression, then it is merely an idea and it is not copyright, right? So like if George Lucas, for example, was talking about his idea of Star Wars publicly, like told all of his friends about it, but he had not like created a movie or created like a script for it or anything like that, that means that someone else could legally take his idea and write it, and yeah, because it's not an intangible medium of expression. Okay, the final type of IP that I want to go over is trademarks. So trademarks protect a brand by distinguishing it from others. They're generally not to encourage innovation, which is kind of distinct from patents, especially. They're just to protect kind of brand name and consistency. Um, Three good examples of trademarks. The first one is Post-it notes. So the yellow on Post-it notes, that specific like hue of yellow is trademarked. There are a lot of colors that are trademarked. Like Target red is also trademarked. So they kind of have the specific hue of that color trademark, so no one else can use that. The reason that we call it ping pong, and also call it table tennis is that ping pong is actually trademarked by the Parker brothers. So like the Olympic Games, if you've been watching those, like they cannot call it ping pong in the Olympic Games because ping pong is trademarked by the like game company, the Parker brothers, so they have to call it table tennis. Um, Again, another Star Wars example, Darth Vader's breathing is actually trademarked, which is colloquially called a sound mark. So like types of sounds can be trademarked because they're kind of like a brand. Oh yeah, and Facebook also trademarked the word face. And so you might be wondering, like, how can you trademark an entire word? Like, that seems ridiculous. That it only applies to the social media sector. So a lot of trademarks are like sectoral specific, meaning that if I like start a company called Apple, but it's not in like the software realm or like anything that has to do with like the actual Apple company, they cannot sue me because like let's say like it's a bike company. Like I can still call my bike company Apple because it's a different sector than Apple's in. So the duration of copyright or trademarks extends as long as it is commercially used. So if you have stopped using it commercially, then you just lose your trademark, right? So you have no more rights to exclude other people from using it in their brand. The rights granted to people who have trademarks is that they can prohibit use of similar looking marks, right? So like on like the Post-it note example, if someone else uses that hue of yellow for their company, then the Post-it note company can kind of sue them and get remedies for their use of the similar looking mark. The way you obtain a trademark is very similar to copyright, right? So once you create the trademark, that is, or the second you create the trademark, it is protected. But the only way to actually defend it in court, for example, is to register with a patent and trademark office. And then the requirements for trademarks, there's three. The first one is that it must be distinct, so it cannot be like a generic term. So the reason like Apple, for example, is distinctive is because it is what the PTO calls an arbitrary um, trademark. So like no one would ever call a computer an Apple. So the reason that it is distinct is because it's like an arbitrary way of designating a computer, right? So like if I'm starting a computer company, like assume it's like literally the beginning of computers. If I start a computer company and I call it like computers, like I cannot trademark that because that is a generic term referring to the product I'm selling. But if I call it like Apple, right, like that's not a way to refer to a computer. So that is still like a distinct way of trademarking. The second requirement is that it's commercially used. So usually the first person to use it gets priority. So if you kind of abandon the commercial use, then it's fair game for anyone else. And the final aspect distinguishes it from patents. So trademarks have to be non-functional, right? So they're not related to like the way a product functions, which is just like the main purpose of that is just to distinguish it from patents. All right. The next thing I'm going to talk about before we move on to the next section is remedies. So I think remedies will be a pretty important part of the topic to understand. There already been affirmatives written about how we remedy intellectual property rights infringement. So the two main types of remedies, there are other types, but they're usually less common, and they usually just are different ways of referring to these two. So the first one is an injunction. So an injunction is when a court enjoins you or orders you to cease using the intellectual property. It can be permanent or temporary. A lot of times judges will issue an interim injunction, which means that like while the case is being decided, they cannot use your intellectual property just to prevent them from profiting anymore or like hurting your brand anymore. Perpetual injunctions means that like you cannot use this intellectual property for good, right? And so you might be wondering, like, what are the punishments if someone does not obey an injunction? The biggest ones are just like more fines and even potentially like prison if you don't adhere to the injunction. So the next type of remedy are what we call damages. So damages can only occur when the infringing party has profited from the infringement, right? So like if I start a company that uses the exact same hue of yellow and I'm selling like paper, for example, like not even sticky notes, and I make like $1 billion off of that, then Post-it notes can sue me and like get the damages from the profits I have earned on their like hue of yellow. Yeah, so the court will determine like how much you get in damages, like what the compensation is based on kind of how much they profited off of your own intellectual property. Okay, the next section is core controversy. So this refers to kind of like where the biggest disagreements occur in the literature. So I think there are six big ones on this topic. The first one is pretty interesting and topic specific. It is patents, whether or not they are good or bad for innovation. So we're going to go through like a few warrants on both sides of why they're good or why they're bad. The second core controversy is what agency should be the one protecting intellectual property rights, who is best, um, who have the best like tools for protecting your intellectual property rights. The third core controversy is the international implications of domestic IP protection. Like kind of what the effects of protecting US IP is on the international field. The fourth section we'll go through are types of IP. So we'll talk about two other forms of IP besides patents, copyrights, and trademarks, and kind of how they play into the topic. The fifth section we'll go over are political concerns. Kind of like how does IP protection impact the political sphere? Who supports more protection? Who supports less protection, etc. And then we'll talk about what strengthening protection means. All right, so patents, good, bad, I think is a really interesting debate. And I think that if you're able to explain the warrants for this effectively, then you can win a lot of debates, especially if people are reading big innovation advantages. So the first warrant, I think, for patents, why they're good, is first movers. So if I'm a small firm and I am able to obtain a patent, that will give me 20 years to have exclusive rights to use that patent to sell products, which is like a huge economic incentive because it kind of blocks out all competition from your patent. That then provides like an incentive to innovate, right? So like if I know that I can get protection on my invention, then I have an incentive to innovate, to develop something new, and then I get protection on it, so then I can sell it. Yeah. And then asset building is another interesting warrant for patents good. So when companies have patents, they can then license their patents to other firms if they want to like use their invention, which means that other firms will pay them to use their patent to like build something, for example. It can also be sold outright. So if I hold a patent that I think is super valuable, but I think that it's more valuable for me to sell it than to use it to like sell products, then I can sell the patent to like a huge company and I can make a ton of money off of that. Also increases like the market valuation of your company. So if you have a lot of patents that have like a lot of protection on them, protection meaning like a lot, like a many more years of protection from the Patent and Trademark Office. So if I have a lot of patents, that means that I'll be valued more in the market. Also means I'll attract more investment because people want to invest in my company. And that then means that I'll be able to fund more research and development, which thereby like more increases innovation. The next warrant is public knowledge. So we talked about earlier, but a lot of the warrants behind why we should protect patents is that if we don't protect patents, then we'll never have like a way of disclosing to the public the exact details of the invention. So after the patent expires, the patent becomes public knowledge, which means that other people can use your invention to kind of like build their own or just totally copy it, which kind of generally promotes like open innovation, which refers to innovation for like everyone and not closed innovation, which is just for like usually larger companies. Yeah, and we'll talk about trade secrets later, but another reason why patents are good for public knowledge is because they prevent people from just relying on trade secrets, which we'll talk about later. The next word is competition. So if I have a patent that incentivizes other companies to create something better, that does not violate the patent, right? So like they have to create an invention that is distinct, but also like makes more money and is better than mine. The final warrant is onshoring, which there have been a number of advantages about this year. But if we have more domestic protection for our patents, that means that more innovation will be held in the US and will not be shared with the world, which can, bring us like tech leadership advantages, like competitiveness stuff. Yeah. Okay, the warrants why patents might be bad. The first one is litigation costs. So obtaining a patent, writing the whole patent down costs a ton of money, and it is very hard to also defend that patent in court. So that's kind of a deterrent for using patents, which means that only like very large companies who have kind of the litigation strength, only those large companies can both obtain and defend patents, which kind of prevents a lot of smaller companies from actually innovating because they won't be able to get protection on their invention, and bigger companies can steal it. The second warrant is monopolies. Companies will often hoard patents via patent thickets, which basically means that which basically refers to when a company has patents, similar patents around one technology, which kind of prevents any competitors, which is a great answer to like the competitors warrant for why patents are good. Those big companies can also just totally dominate smaller companies just because they have more money to fund litigation, which we talked about with the last warrant. There are also the evergreening warrant, which you might hear about this year. Evergreening refers to like tiny adjustments to extend the life of a patent, so that it will never be disclosed to the public. So like if I have a patent on a drug for tuberculosis, for example, and I maybe like tweak it a little bit so it's more effective, I can apply for another patent. And if the patent office thinks it's like new, it's novel, then I will get like a whole nother patent on my product, and then I can kind of extend it so no one else will know about it. The next warrant are patent trolls. So a few decades ago, a bunch of lawyers saw an opportunity to make money, and they decided to file for patents that they were never going to use, never going to practice with, which is why they're called non-practicing entities. And then they sued firms who don't have a patent on that invention, right? So these patent trolls, their only really purpose is to make money by suing larger companies who like forgot to get a patent on one particular part of an invention. Patent trolls are now a huge problem. There are even like finance firms that invest in patent trolls because they work on a contingency fee, which basically means that if the patent troll, if the non-practicing entity, if that lawyer is successful in winning their case, then they get paid. But if they're not successful, they don't get paid. So there's a huge incentive for those lawyers to win their cases. The reason why patents, like why that means patents are bad, is that if we increase more protection for patents, that means that trolls can exploit the system more. The next warrant is a short-term gain. So if you focus on just getting that patent rather than refining your product, as we talked about earlier, that can mean that you might not like be producing the most innovation. The next warrant are developing nations. Domestic patent protection can disincentivize international tech transfers because a lot of places rely on U.S. innovation, specifically like in the pharma sector. We'll talk more about that in a second, though. The next core controversy, I think, is the agency that should carry out the plan. So I'll just briefly go over kind of the role of each branch of the government and specific agencies within each. So first is Congress. Their role is to create legal regimes for intellectual property. So all the laws we talked about earlier in the copyright history, those were created by Congress. They changed the duration of copyrights. Also, we talked about like first to file and first to invent. That distinction was determined by Congress. So like they have the control over creating like legislation and laws for IP. So the second branch is the executive branch. Their role is to interpret those laws that Congress creates via administrative regulation and other forms of administrative rulemaking. So the two big agencies that you should know are the U.S. Patent and Trademark Office. They handle patents and trademarks, obviously. They issue rulemaking over patents, so they kind of interpret what the laws say. So we talked a lot about like eligibility earlier for patents. They're the ones who kind of define what those terms mean. So like a abstract idea, they're the ones who decide what are the qualifications for an abstract idea. Within the Patent and Trademark Office is the Patent Trial and Appeal Board, which is kind of the application process for patents. The other office worth knowing in the executive is the Copyright Office. They are in the Library of Congress and they administer copyrights and when people apply for copyrights or seek protection. Yeah. So the final branch involved in intellectual property obviously is the courts. They interpret laws via specific cases. So they have a similar function to the executive in that they're kind of like an enforcement body for intellectual property rights. The way that patent appeals work is they start in the Court of Appeals for the Federal Circuit. So all of them go to that singular court, and then they can be appealed to district courts, and then finally the Supreme Court. There's usually like one IP case before the Supreme Court every 4 years. So it's not like super popular in the Supreme Court, but there have been a number of really important decisions that it's worth knowing. The first one was the eBay decision. It had to do kind of like when injunctions were issued. So it set a standard for when they should be issued automatically, which means that it kind of led to less injunctions being issued automatically because there have to be a certain number of requirements met. It's pretty complicated. I'm not that well versed in like those requirements, but it did lead to less automatic injunctions. The Markman decision, uh, it kind of stated that judges and juries are responsible for interpreting the language of patent claims. So a lot of patent lawyers will tell you that like it's very difficult to convince a jury of a certain thing because patent law is very complicated. There's a lot of complex technical distinctions that the jury might not understand. So the Markman decision kind of shifted the role of who evaluates kind of the case to judges for matters of law, not for matters of facts, but for matters of law. The Alice decision, you will definitely hear about this year. It tightens standards for eligibility. So we talked about kind of like those things that cannot be patented. The Alice decision affected that. Specifically like in software business methods, it tightened like what actually can be patentable. So there will be definitely be some affirmatives this year that try and change those eligibility standards. International implications of IP protection. The first one is trade relations. Stronger protection might attract more foreign investors because they want to achieve the protection in the United States. That kind of opens up possibility for advantage ground. The Emory debate camp produced an AI copyright app that had an EU relations advantage, which is kind of an example of international implications of the topic. There also might be disads about like stealing foreign investors or nations backlashing to more U.S. protection. The second warrant is, or the second implication is economic disparities. So we talked about this a little bit earlier with developing nations. The best example of this, I think, is the COVID response. So India and South Africa in 2020 submitted a proposal to the World Trade Organization to suspend IP on all COVID vaccines, which basically means that like Moderna, Pfizer, their vaccines, the like design and the specific details of their vaccine had to be disclosed to the entire world, which would have driven potentially a better response to COVID if more people that have access and can build the vaccines. The WTO ended up adopting it after it was severely watered down, so it wasn't really what South Africa and India hoped for. But that's a really good example of kind of economic disparities because a lot of developing countries do not have access to the innovation and kind of would prefer less IP protection for US IPR. Organizations involved in intellectual property. The World Intellectual Property Organization has a lot of influence on ILAW and international law for intellectual property. They generally support harmonization. They're part of the United Nations. The second organization is the World Trade Organization. They settle a lot of disputes between nations on intellectual property. They enforce TRIPS, which we'll talk about in a second. The international agreements that I think you should probably know. The first one is the Paris Convention. It was one of the first international agreements over intellectual property. It laid the groundwork for IP protection, and it generally supported like harmonization of the law between countries having similar standards. It is administered by the World Intellectual Property Organization, still to this day. The Berne Convention was set standards for minimum copyright protection. So kind of like what each country who signed on to it had to do like as a minimum in protecting their copyright. It then merged and is still administered by the World Intellectual Property Organization. And the final one is TRIPS, which I think you'll definitely hear about this year. It's the trade-related aspects of IPR. Was created in 1995. It added more minimum requirements for protection, specifically as it relates to international trade. Okay, and then the next thing we're going to go over are other types of intellectual property. So the first one are trade secrets. So these are distinct from trademark, copyright, and patents. They protect information, which you may think that's like very, very broad. Like what even is information? Well, the broadness of it is very intentional. Trade secrets kind of can really protect a lot of things like processes, designs, drawings, methods of how a company works, like even like a list of suppliers could be like a trade secret. The duration of them, they're unlimited, which kind of provides a large incentive for companies to rely on trade secrets instead of getting a patent or a copyright or even a trademark. The rights granted, they do not have as much protection as other forms of IP. They can only prohibit illegitimate competition. So let's say like I run like a computer company. If I make all my employees sign non-disclosure agreements on the contents and how my computers are created, then they cannot go tell like my competitor how my computer is created. Right. So like that would be an illegitimate form of competition. But a legit form of competition would be like if my competitor went out and bought my computer, took it apart, and figured out how it worked. Like that's legit. So you cannot protect that stuff, even if they end up making something exactly the same as your own product. So that's why it's kind of like less protection afforded to the rights holder if they have a trade secret. The obtainment process, there is no registration. You can defend it without registering. It just has to meet the qualifications for what a trade secret is. Then those requirements are three things. So the first one is that is unknown. Oh, hold on. Yeah, the first requirement is that it is unknown, which means that no one else kind of knows the secret, obviously. The second one is that it's economically valuable, which means that it has to be useful for your company and generating profit. And the final one is that it's actively protected as their secret by the owner. So my favorite example of a trade secret is the Coca-Cola formula. So Coca-Cola, instead of getting a patent on the drink recipe, as some other companies do, they have a trade secret. And the reason is because they want to keep it forever and never have to disclose how Coke is made. Because like then Pepsi could just totally copy it. And so that's why they don't file for a patent. So Coke kind of like protects their formula. They don't want anyone to know it. It's supposed to be very secret. And so the reason why like Pepsi can be taste so similar to Coke is because Pepsi has engaged in legit competition with Coke and just trying to match the flavor, but they have not like stolen the recipe from like the secret Coca-Cola bowl, which would be like illegit competition. Okay, and the next form is sui generis. So sui generis is a Latin term. Sui in Latin means like its own, it's a reflexive pronoun. Generis means like a type or a kind. So together that means of its own kind. So it's really just like a unique form of IP protection, and it's very flexible and kind of like what it can look like. So it can really protect anything, any kind of intellectual property. There are two big examples of them that are like in like the Western world. The first is the EU has a sui generis regime over like databases, online databases. And the duration of that is for 15 years. The US has a sui generis regime over semiconductors, and that one is for 10 years, right? So like the duration can be determined by whoever sets up the regime. So if you were to read a counterplan that set up a sui generis regime, the duration could be however long you liked. The rights granted can really be anything. It just depends on like the specifications of the sui generis regime. So that kind of might introduce some like competition arguments for why it's competitive. The obtainment process again can be any process. It just depends on how you set it up. The requirements, there are typically fewer requirements to like be admitted into a sui generis regime. But again, it really just depends on how you set it up, and which kind of affords a lot of flexibility if you want to read this as a counterplan. And the reason I bring both of these two up is just because I think they're like distinct forms of IP protection that might be counterplans on this topic. So it's worth like understanding them. The fifth core controversy is political concerns. So this kind of just refers to like who wants more protection and who wants less protection. So the people that want more protection generally are unions, small businesses, and Republicans. So worker unions, as we talked about before, they want their own intellectual property to be protected from their corporate overlords who kind of like take their ideas, right? So like if we afford more protection to these workers, then if they create something on the job that can like make them a ton of money, then they will be able to protect their own invention. Small businesses also want more protection because they don't want big businesses to take their ideas. Republicans generally want more protection, although it's never really been clear like what the party lines are. It's part of kind of like a libertarian outlook and protecting their property rights. And then the people who oppose protection are generally, and this is not always true, Democrats generally want less protection. The most recent example was the COVID example I talked about earlier. Democrats wanted the US to kind of get rid of IP protection so that developing nations could have access to the drug designs that Big Pharma built in the US. Other businesses that oppose protection are big businesses, big tech, and big pharma. They generally don't want smaller companies to kind of like have more protection from them. They want to kind of engulf them. Yeah. But the other thing I will say is that like any of these groups could also be the other way, right? So like big businesses, if they're the ones being protected, they obviously would support that form of protection. If small businesses, if their protection is supporting the big businesses, then obviously they'll oppose that protection. So it really just matters kind of like what the protection is, and like who the IPR is protecting, right? So like it is very, very murky on like the political concerns on this topic, which means the politics of that is not as good. Yeah. Also, like very few people really care about IP protection. So politics is like not a huge thing on this topic. The sixth one is just a sixth, not fifth. The sixth one is the definition of what strengthened protection means. So there's two different ways to define it. The first one is that protection means that you have to make it easier to obtain IPR. So that means like you reform procedures for how people can obtain patents. You change eligibility standards. You change other standards for like what a patent is, what a copyright is, what a trademark is. And the second definition of strengthened protection is to enforce IPR more effectively. So that means like you might increase like the fines if you don't, or if you infringe on someone's IPR. So here are two examples of definitions that kind of distinguish what strengthened protection means. So this piece of evidence says that there's two distinct elements of IPR systems. The first is IPR protection, and the second is IPR enforcement, right? So like protection is changing those eligibility standards, determines like which assets can receive protection, and then protection is the active enforcement of those intellectual property rights. Or no, protection is not enforcement. Protection is like making more things patentable or can receive enforcement. And then enforcement is like increasing fines, that kind of stuff. And then another definition, this card says like protection actually just means enforcement, right? So it's not about like changing the scope of intellectual property rights. It just means that there are more fines. It's like more effective enforcement of those rights. All right. And then the last two sections are not too long. The first one is affirmative. So we'll go through the three topic areas and talk about different ways of writing apps within each of these. So first are patents. I think this will be the largest app area. Big things to think about on patent affirmatives. The first one, the first type of apps, I think, are apps that expand eligibility. So there are a number of apps in many camp files that make more things patentable. So we talked about those like 8 things that are subject matter that are excluded under current standards. A lot of affirmatives this year will kind of redefine those terms or eliminate them entirely and say that like those areas need to be patented for whatever reason. So I would look into each of those definitions. The other thing is kind of resolving under enforcement. So if those patents are not protected adequately by the courts or by the Patent and Trademark Office, an affirmative can kind of like ramp up enforcement of those. They can also eliminate procedures that invalidate patents. So the things called like inter partes review, which means other parties can challenge the validity of patents. That might be another area for affirmative ground. There's also like you can eliminate threats to patent validity. So right now, for example, there's like a circuit split over whether like a demonstrating your own invention implicates the validity of your patent. Because like if patents are in public use, as we talked about earlier, before you try and apply, that makes them invalid. So there's like a circuit split over whether or not like demonstrating your invention is like actually public display. But really, I mean, if you choose like any technology that's like a new and emerging industry, there are bound to be advocates that say that it should have more patent protection. So really there are just like a lot of apps under this section that you could find. Yeah. So for copyrights, there are not as many apps. A big one is artificial intelligence. So AI right now, a lot of like the large language models operate under what we call like the fair use exception. So copyright, even though like it's intended to, it does not mean that like nobody can ever use a work without permission. So like if you have like a teacher, for example, who takes a paragraph out of a book and shares it with the class, like that's not technically violating copyright. Um, and so like that is still legal. And because like under the fair use exception. But no one really knows what fair use means. So AI companies that are like using these large language models are operating under the fair use exception. which means that they can like use all data on the internet, anything even you've created, like your a piece of writing you've done that's on the internet or something like that. Those are all protected under the fair use exception. So an app that might want to limit AI and limit their use of your own copyright might increase protection and remove that exception for artificial intelligence. Deep fakes are also an example. So like, do you have copyright protection for your own image, right? So your face, like, can you protect yourself from AI or like images or like deep fakes of yourself? So that might be an affirmative this year. Digital piracy was an affirmative put out at one camp that had to do with like protecting uh, your online information, just digital piracy. Music obviously is a huge element of copyright. Well, less important for debate, more important for the real world. But there could definitely be affirmatives about that. Indigenous traditional cultural expression. There's a lot of articles that talk about ways that like we should protect cultural expression of indigenous peoples. So that will definitely be an element of the topic. Music and a music industry I talked about. Global harmonization. There could potentially be apps that just rely on like getting more countries on board with the US copyright protection. I haven't really seen any of these, but they're definitely out there. Okay, so trademark affirmatives are even smaller, in my opinion. But big ones, I think, are counterfeiting is a huge one. So that was kind of like a big affirmative, at least at the Michigan camp this summer. There's a lot of arguments why like people need to enforce trademark protection more against counterfeit. Drugs also, marijuana trademark rules, psychedelic trademark rules, other things like that. Indigenous appropriation will also have some trademark affirmatives, just in the name, like the use of their image or their name, in like, like NFL teams, for example. And then cultural appropriation more broadly will certainly have affirmatives in that, in the trademark area. And then the next thing we're talking about is neg angles on the topic. So I chose kind of 8 neg arguments that I think we should talk about. The first one are case of property. My opinion, I think these are the only topic generics, because I think a lot of apps don't link to anything else. So you should definitely be like familiar and good at going for the cap K or K specific to IP or really any K of property, because I just really think it's the only topic generic. Other arguments are like non-traditional IP counterplans. So we talked about sui generis and trade secrets. Those can be other forms of protecting IP with net benefits about like spillover within just patents, trademarks, or copyrights, or reasons why that sui generis regime is itself useful and is itself mutually exclusive with traditional forms of IP protection. Another argument are court disads. So a lot of apps might increase litigation in the courts, which might cause court clog, which would trade off with other cases in the courts. There also might be court capital disads, sua sponte, ruling without a precedent. Also, just like setting a precedent, there might be disads based on that, like the way the affirmative is constructed will cause a precedent that is bad for whatever reason. Innovation disads are also something that will be a neg argument this year. There will be a lot of articles why IPR might be worse for innovation. We talked about patents good, bad before. I think that'll be really useful to be well versed in, because I think a lot of affirmatives that change patent eligibility will have big advantages about generally the patents increase innovation. So if you are kind of well versed in why patents decrease innovation, then I think that will be really useful. The next thing are trolls disads. So increasing protection might allow those non-practicing entities to exploit the system for financial gain because they have more protection from big businesses they are suing, which could cause X, Y, and Z, like bad things. Trolls flooding the system could be like just a court clog link. Process counterplans will be useful, I think. I think there are a good amount of like IP specific counterplans that kind of like offer a distinct process for adopting like more protection measures. So that will definitely be something on this topic that's worth looking into. Another thing are agent counterplans. It depends on competition stuff we talked about earlier. Politics disad, agenda politics, and horse trading will be big. I don't think there's a great link, but definitely worth looking into. And then I do have to do a shameless plug here. So the Policy Debate Central is a website I co-manage. We post YouTube recordings of debates. We do podcasts with topic experts and with former high school debaters about a lot of interesting stuff I think will be useful for y'all. We also do news stories on high school debate. And the second website that I do need to plug is from Trufanov. It's a fantastic website called Debate Decoded for people looking to improve their debate skills. It's a great service, and I think it's a low cost for like the value it provides. And if you have any more questions on it, Truth is happy to answer them. He was on one of our podcast episodes. It was super helpful and super excited about this project he's working on. Yeah, so if you have any questions, I'm definitely open to those now.
I actually have one quick question.
Yeah,
It was kind of back at the when we were covering about like what patents and trademarks are.
yeah.
Well, there were like two offices you mentioned. The patent trade, yeah, that one. For
Mhm.
trademarks, you mentioned the obtained through the patent trademark office, and then but for patents, you said it's through the patent.
Yeah,
What does
yeah,
it mean? Patent PTAB?
yeah.
Can
So
that
the
not go through the PTO either?
yeah, so that is through the PTO, but the PTAB is like a specific part of the PTO. So I'm
Oh,
sure there's like a specific office for copyright. I'm not familiar with it, but I just know that like both of them are part of the PTO or for trademark, sorry. Both of them are part of the PTO, but like the PTAB is just like a specific yeah, part of that.
okay. And I was a little bit confused about trade secrets still.
Yeah.
Like, I kind of get what you mean by the Coca-Cola
Hmm.
example. It's just in general, it's still a little bit confusing for me. Could you like give
Yeah.
me more example?
So trade secrets can really protect kind of anything that could be patentable or given copyright protection. So the reason that companies might prefer trade secrets is that they kind of, well, the big reason is that the duration is unlimited, right? So like Coca-Cola, they have a drink that could be patented. They could write a whole application on what the recipe is for the patent, but instead they want to keep it like a secret, right? So like that's why it's called trade secrets. And so they keep it for forever, while they like are like they keep it for forever as long as they like protect it. And the reason why it's like not as effective as a patent because you don't have as many rights to protect it, right? So like you can't go to court and sue someone if they use it if they've like obtained it via legitimate competition. So like if someone like buys a Coca-Cola bottle and like takes it to a chemistry lab and breaks down all the elements and then they like make Pepsi, right? So like that's I'm assuming that's how that happened, right? That is a legitimate form of competition, so I cannot sue that company. Like that's why Pepsi exists. Um, but if like, for example, someone who works at Coca-Cola who signed a non-disclosure agreement, which means they do not disclose like what they build, like the what the recipe is for Coke, if they like invite someone from Pepsi over, like to the company, and they like show them the recipe or whatever, and then like Pepsi copies it, that is an illegitimate form of competition, and they are like not allowed to do that, right? So like that is when trade secrets are protected.
Okay, how would like other companies know? Like, let's say Coca-Cola does file for that, does make a trade secret.
Mhm.
How does it let other companies know that what they have is a trade secret?
Yeah. So, the way that works is companies can file what is called like a cease and desist letter. So Coca-Cola will like deliver a letter to Pepsi saying that you need to stop selling this product because like the recipe that you've like stolen from us is like a trade secret. And then they explain how like it is unknown, valuable, and protected by us. And then if Pepsi does not stop, then they can take it to court. And if it qualifies as those three things, then the court and the court determines that the other company has stolen it illegitimately, then at that point they can then seek remedies like through injunctions or damages.
Oh, okay. So like other companies need to be careful on how they make their products sometimes
Yeah,
because
yeah, yeah. And I mean, like, it has definitely occurred where a company has not realized that they have kind of like, like stolen someone else's trade secrets and they've been sued. But I would say generally, a company like they'll know like when they're engaging in illegitimate competition. But then again, like it is hard to kind of distinguish like what is illegit and what is legit because like if Pepsi were to go out and buy a Coca-Cola bottle and examine it, like that is still legit competition. So even if they like are able to make a recipe for a product that is the exact same as Coca-Cola, that is not protected by trade secrets because it was a legit form of competition. So Coca-Cola, the burden of proof on them is to prove that someone like stole their idea by like violating some like non-disclosure agreement, for example.
Oh, I see what you mean now. Okay. Could you give one example of sui generis though?
Yeah, so sui generis, it can really apply to anything. So a lot of times when something doesn't really fit into copyright, patents, or trademarks, then a company will offer a sui generis regime. So the US only has one, and that's for semiconductors, which are basically tiny microchips in your phone. Those are kind of like people aren't really sure whether they are patents, copyrights, or trademarks because they're kind of in between. And the US also wanted to give it like very specific protection because like there was a lot of lobbying from the industry that they have like specific requirements on like how long it is and that kind of stuff. So they created like a whole separate regime where they got to choose all the rules and it did not have to obey like the existing requirements for patent, copyrights, and trademarks. Does that make sense?
Sort of, yeah. Do you know any like, is there like another example you know though? Is that like the only main one?
That's the only one in the US. The other big example that I think there's a lot of people who write about is the one in the European Union. So
Okay.
they protect online databases, which like I mean I would assume they like should be copyright, right? Because it's kind of like a form of expressing
But
literary
I know
work.
the idea on open case list.
You what? Sorry.
I like remember finding something about those EU databases on open case list.
Yeah, yeah. Um, so that's the other good example, but the EU decided that like those databases need their own special kinds of a protection. So that is why they kind of adopted the sui generis regime.
Okay.
Um,
Good.
yeah, there are a few other examples, but they're like a lot smaller and like a lot of the literature just talks about these two.
Thank you.
Yeah. Yeah, Venkata.
One question I have is like about the evergreening stuff. So what prevents the company from just like other companies from just selling the old version? Like how does evergreening sort of work?
Uh, yeah. So the way that evergreening works is that if companies can prove that they have changed their product, that makes it kind of distinct from the original patent, then the Patent and Trademark Office offers them an extension on their patent. So it like applies to the existing patent, right? So like that patent does not go to the public domain.
Oh, so
They just get an extension on it.
like the old patent would basically never expire.
Yes. I mean, it will eventually, but like the patent will be extended because they've proven that like they have the new aspect of it.
Okay.
Yeah, I'm like 90% confident on that. That could be wrong, but I'm pretty sure that's how it works.
And another question I have is like the courts. So
Yeah.
like I've heard some things about like the court like system for intellectual property being different from the traditional one. Like
Yeah. So the big thing is just that all appeals go to the Federal Circuit Court of Appeals. So like let's say you apply for a patent and the Patent Trial and Appeal Board um says that like it does not meet a certain eligibility requirement, you can then appeal that, and that goes directly to the Federal Circuit Court of Appeals. You can appeal that and say like that's not right. Like we do meet this eligibility requirement, or like this eligibility requirement isn't like constitutional, or like the way that the Patent and Trademark Office is interpreting it does not align with like the congressional intent of the statute. So like that is the main distinction on how that works. There are some people that advocate we should create a whole separate judicial system for patents, like a specialized patent tribunals. So that is definitely something you might see this year. But generally the main distinction is that they all go to the um, one appeals court, and then they go to the district courts after that, and then Supreme Court.
yeah, so like would you think like there would be any like affirmatives that would like basically redirect all of this to the USPTO and create a sub branch of that for
Yeah. I think it would depend on like obviously like the definitions you read on topicality about like why protection means more enforcement, but I think there definitely could be affirmatives about like changing the way and the process that like patents are enforced if they're infringed, right?
yeah.
Yeah.
And like another thing I have is like basically about the docket in courts. Like
Mhm.
how does the docket for intellectual property work? It's like especially in relating to court cognizance.
Yeah, I don't think it's like any different than other cases. It's generally just based on what the how the judge wants to manage their own docket. But I do know that like a lot of judges, if they aren't a patent specialist, they really kind of despise patent cases because they're very technical and it's very like it's very difficult to determine like whether or not a certain invention is distinct from another because they could be like super complex, like semiconductors, for example, where they're like a lot of technical terms that you don't really understand. So a lot of judges will kind of uh despise having patents on their docket, but they're it's not like they get a different priority when they go through the system.
All right, that's my, oh, that's it. Thank you.
Yeah. Thank you. Brian?
Yeah, I had a really quick question about like PTAB as an organization. I know I've seen like PTAB harmonization as an app and inter partes review. Do you think like those are viable throughout like the season?
Yeah, I think they're
I
really
think they're
good.
really good.
Sorry, could you mute just so it doesn't echo? Oh, there we go. Okay. Yeah, I think those apps are pretty strong. I think the inter partes review is pretty good because you get like that big innovation advantage and why patents are good. And then there's also like the precedent set by making PTAB decisions non-binding on the courts. So yeah, I think there's a lot of app innovation opportunity with the PTAB and with the US Patent and Trademark Office because there's like a ton of articles that are like the USPTO and the PTAB, like the process is just horrible. Like they don't interpret rules correctly. They result in a ton of patents being denied. And so like there will definitely be affirmatives this year that say like we should just change that process entirely and then have a big advantage to why patents are good.
Yeah, that makes sense. What like weaknesses do you think the apps have?
I think one weakness is that like the issue with big patent good advantages is kind of like I mean like those apps will like have to have them is that they kind of are prone to a lot of patents bad arguments, right? So like if I have an advantage that's just generally patents good and I have three scenarios about like green patents for climate, like pharma patents, and like patents for cybersecurity, right? If the neg can really read like any impact earn, for example, of why patents are bad. So you have to be prepared for why like patents are good for like nearly every sector. So like that's my biggest fear when writing a big innovation app like that. It's just like you have to do a ton of preparation on like a ton of different reasons why patents are good for like every sector. Um, yeah.
Yeah, it makes sense. So it's probably like weak against like advantage counter plans with like prizes and like ban patents, I think.
Yeah, I think so. Because I mean, prizes definitely good versus advantages because usually like the best answers to prizes are like about specific sectors. And if you're just reading like a big advantage about innovation broadly, then prizes probably solves that. But I mean like there's still answers to it. So I would be afraid of patents ban and prizes if I was reading a big advantage, innovation advantage with like a PTAB harmonization app. Yeah.
All right,
But I
thank
mean,
you.
I think those apps are definitely still viable and they can be executed effectively, definitely.
All
Yeah.
right, thank you. Yeah, makes a lot of sense. Yeah.
Lakita?
Can you explain more about the Alice decision?
Sorry, the which decision? Alice? Yeah.
The Alice decision.
Yeah. So the way the Alice decision worked is that it tied in standards for what is kind of like an abstract idea. So we talked about the eligibility standards earlier on kind of like what subject matter is not patentable. So the Alice decision is specifically like in software and like how computers are constructed. The Alice decision set a standard and kind of outlined more stringent requirement um for like what can be patentable. I don't know like the very specifics on what was the subject of the case. But the general gist of the Alice decision is that it made a lot of things that software companies wanted to patent not patentable based on those like non-patentable subject matter.
Okay, thank you.
But I can definitely like send you more details on that decision. The Alice Mayo test, which is something you might hear about this year, is probably the most complicated aspect of the topic just because it's very like legally arcane and like hard to distinguish the two. But I can definitely send you some stuff after this. Streetcars next.
Yeah, when you were explaining like the neg angle stuff, and you said that like process counterplans could be like a big part of this topic, do you have any like specific like counterplans?
Yeah, I think there's a few in the Michigan camp files, which if you don't have access to, they're both on Open Evidence and on the Policy Debate Central website.
Mhm.
There's a few in there about like creating new offices for like copyright reform. Like I know that was one of them. There's also process counterpoints about like instead of using like patents or IP protection, you can like tax people to kind of get the same result as the plan, which isn't really a process counter plan, but I mean, or like in the common sense, but I think it's a distinct way of protecting intellectual property. So those are two examples, but I would definitely look through those files because there's a lot of other stuff put out in there that I don't know about all of them, but there's definitely more in there.
Okay, thanks.
Yeah. Any other questions?
Yeah, I actually had another one. When you, it's actually about counter plans. I know you may not have mentioned it in this lecture, but do you think you can explain to us how advantage counter plans work? Because a week ago when I was looking through open case list, I came across some files that had advantage counter plans, but when I clicked into them, it just seemed like there was just a bunch of random counter plans within just one file, and I was kind of confused on that.
Yeah. So the way that advantage counterpoint works is they try and argue that we can solve the affirmative's internal links via like another way, right? So like I think a good example is like climate change. So like if an app is like we need more patents for green technology, we need like more renewables to be patented, like the way that like a turbine is built. And they say that is key to mitigating climate change because those renewables will like displace fossil fuels in the market, so we will emit less, right? So like that's the affirmatives claim. An advantage counterplan would then say the way that we can also stop warming by like sucking all the carbon emissions out of the atmosphere, right? So like it's just an alternative approach to solving the impact level, not like the internal link level, right? So like usually like an agent counterplan or process counterplan tries to result in like the exact same thing as the plan, so it solves all the internal links. But an advantage counterplan is like we don't need your internal links, like we can solve the impact like better, right? And so it does not have to do anything with IP protection, which means that it avoids any disads that are like IP protection is bad for XYZ reason.
Okay, so like it's mainly just like preparing for specific types of app cases you could come across and just
Yeah.
write.
Yeah, so one thing I think will be useful this year is because there's going to be like a ton of different affirmatives that have different patents. If you have like a big file of solving all the major impacts like climate change, food insecurity, democracy, like those kind of stuff, or like tech leadership, if you have a bunch of different advantage counter plans that can solve those impacts, even if it's like a different app with those impacts, then I think that'll be pretty helpful so you can read, so you can solve a lot of the case and still read disads based on IP protection. But if you have more questions on advantage counterpoints, I would definitely ask your lab leaders because they can definitely help you with those.
Okay, thank you.
Yeah. Brian, do you have another question or is that still from before?
Oh yeah, that's from before.
Okay. Any other questions? Did anyone want
Awesome.
any more like clarification on specific parts? I know I went pretty quickly through it. Okay.
How would like the K debate look over this topic usually? What do you think it would look
Yeah. Yeah.
like?
So I think a lot of the K debate this year will be critiques of the idea of property, right? So a lot of like settler colonialism critiques argue that kind of like the Western notion of property we talked about earlier with like John Locke, that is like inherently violent in the fact that like people can claim ownership over other people's ideas. So there's a lot of literature in kind of like the settler colonial field, also in like critical race theory about why like historically IP has been used to like steal the ideas of minorities. I know there's a lot of stuff in like the copyright area, and like music and how like people have profited off of like the backs of minorities and like their own IP. So I think there's going to be a lot, definitely, of K debate specifically about like property. But I do think like everyone should kind of like at least research a little bit into like the core philosophical justifications for property. because I think that'll be a big part of K debates this year. Yeah, Rashad.
Yeah, so for like a prizes counter plan or a process counter plan, and if our net benefit is a patents bad disad, in the counter plan, should we have a plank that says to get rid of patents?
Yeah, I think that is definitely, I think that's definitely a good idea in most cases. Yeah. Um, there are sometimes issues to like whether or not that part of the counterplan competes, right? Because like the affirmative might not technically like rely on patents. And so it like could hypothetically be compatible with like abolishing patents. But I definitely think that's important just like on the uniqueness level of why patents are bad. But then again, like it's not always necessary because if the AF is claiming that like the current system means that all patents don't work, then they have kind of set up the uniqueness for your disad, right? Because you're saying patents are bad, patents are ineffective now. They have already agreed patents are ineffective now just based on the way their advantage is constructed. So you don't need to like abolish patents, right? So like I think it depends on the case, but I definitely will be ready to like abolish patents with your prizes or advantage counterplan.
Yeah, that makes sense.
What exactly is a prizes counter plan?
Yeah, so the prizes counterplan, instead of offering like patent protection to people, it offers like financial prizes for people who innovate, right? So like in the patent system or the IP system, if someone innovates, they apply for a patent, the reward is that they get protection over that patent, no one else can use it. Prizes counterpoint is like if you innovate, if you build something new, if it's like similar standards to patents, like if it's like novel, if it's like economically beneficial, then the government will like offer you money to like further innovate or like even just profit off of that. So like the prizes counterpoint is like if we just provide a financial incentive for people, they will still innovate as much as they would with more patent protection. Does that make sense?
Yep, and I also have one more question.
Yeah.
So I've seen like some camps put out states counter plan on this topic.
Mhm.
How would that work, especially like if it's completely controlled by the USFG?
Yeah. So states counterplan I think is not as popular this year. And why I didn't bring it up is because both patents and copyrights are exclusively controlled by the federal government. So the states have like absolutely no control over those. Trademark law is a little different because it's kind of shared between both the federal and the state governments. So if you are interested in writing a trademark affirmative or writing case next to trademark affirmatives, I would definitely think about like which actor has control over the protection of that. I know there's a lot of like state courts who are involved in trademark protection. So yeah, so that's generally how it'll work this year. It will not really be very popular, and the only way to really win the state's counterplan is if you win like the federal government follows on with something, right? Because like the states don't really have authority over like 99% of IP.
I actually had a quick question. I think it was Rashad who mentioned something about the patents bad DA.
Yeah.
Do you think it's like going to be a popular dissect? Because I saw it too, and it didn't really seem like it would be a good dissect to run in front of like maybe a lay judge, for example.
Yeah. Um, I might disagree with that. I think that if you like I think lay judges might be better for like the patent bad decide because it really gets at like the core of the topic. Um so like if you argue the patents are worse than for innovation and you explain all of that, I think that will be like very persuasive to lay judges. Because I think like a lot of the other parts of the topic are like might be like totally worse. Like if you have to go for a process counterpoint in front of a lay judge, like they would not like that obviously. If you have to go for like a K of property, like I think patents bad is actually a lot better paired with like the prizes counterplan. So like if you are someone who like debates in front of lay judges a lot, I would definitely invest in patents bad or just like generally trademarks bad, copyright bad for innovation stuff.
Okay, what about like running like a codes clock DA and doing a patent pool counter plan?
A patent what counterplan?
A patents pool counter plan? Have you heard of that before?
No.
Okay, it was something I came across in open case list, and it's something I kind of constructed together. Basically, it's kind of like the United States federal government or maybe some sort of international entity could like create this kind of patent pool where like rather than trying to expand patent eligibility, we rather like sort of create this little pool where innovators can like sort of share the patents together in some way and do
Yeah.
some
Yeah,
license.
yeah.
And I
Yeah,
heard that.
that I think that would be good with clog decided, yeah, definitely.
Yeah, thank you.
Yeah. Alan?
So, when you were talking about the app angles and in the patent section, I think you said something about under enforcement.
Yeah.
I just didn't really get
Yeah.
that.
So generally there is an issue right now where a lot of people in the literature think that like patent protection is not being enforced enough, right? So like the courts or like the Patent and Trademark Office are not doing enough to prevent other people from infringing on your patent rights. So an affirmative could theoretically like ramp up enforcement of those patents. They could like beef up the Patent and Trademark Office so they have more like tools to use to get people to stop infringing on your patent rights. They could also remove certain measures in the government that invalidate patents. Yeah.
So it could be something even as simple as like more fines or something.
Yeah, yeah. I think
Okay.
stiffer fines, there are definitions that are like stiffer fines are a way of increasing protection. Another one that I think you should look into if you're interested in under enforcement, or not really under enforcement, but kind of that area, is the inter parties review. So right now there's a law that like any third party can make a claim in the patent office that a certain patent is like illegitimate, like should be invalid for whatever reason, for like not meeting eligibility requirements. And so that is a way that a few patents have been like revoked. And so that might be like reforming that process, making it harder for people to do that will be a way of like strengthening protection. So there was an AF in the Michigan Camp Files that had to do with inter parties reviews. I would definitely look at that.
All right, thanks.
Yeah.
I had just one last question.
Mhm.
Is it necessary to include internal link cards for a disad? Because like I wanted to like let's say I wanted to run 3 off cases and maybe a lay around, but I felt like one of the internal links in a disad was like taking a little too much. Is it okay if I like cut that off?
No. So you need to have like the full like disad story.
Okay.
Yeah. Oh, sorry, I just saw the chat question. Yeah, Lockean ontology just refers to like philosophy based on John Locke. So like the basis of US property law is kind of centered around like what John Locke theorized about property. So like property is like a naturally occurring phenomenon. So like it's part of nature, but when one person improves a certain part of that nature, they then own the right to that property. So like I guess in the context of like people who like settle the Americas, they believe that they had the right to the property because they like improved it for whatever reason, right? So like the reason they thought they could take it from indigenous peoples is that they like improved the property, and based on like what they understood to be property based on like John Locke's theory, they thought that was their own property. So like that's what a Lockean ontology is. Yeah. Any other questions?
Writing down it.
Okay. If nobody has any more questions, thank you so much, Raleigh, for super informative lecture and creating like the whole slideshow and everything. He put a lot of work into this, researching beforehand. So we really appreciate that. For lab placements, we have added everyone to their respective Slack groups